Sounds good. I'll go ahead and get started. Doesn't look like we have any more participants fall in. Hi, everyone. I'm Chad from CAIOC. I'm the Sales and Marketing Assistant here. I just have a quick couple words about CAI before we get started. The Orange County Regional Chapter of CAI provides education, networking, resources, and advocacy for community associations and the professionals and volunteers who serve them. We are a nonprofit association working to build better communities with 64 chapters worldwide, including Canada, the Middle East, and South Africa. There are over 5,000 HOAs in Orange County and 8 regional chapters in California, with CIOC being the largest in the state with over 1,400 members. We have a great panel of speakers today who are all CIOC members. Now I'll go ahead and turn it over to Scott Clements from Reserve Studies Incorporated. Thank you.
Good morning. Thank you very much. We appreciate the opportunity. This is our second year working with the Orange County Realtors with CAI. Our goal is to work together because we have so much in common. Of course, we have a lot of clients, we have a lot of members in common, and we have the same goal, which is a positive outcome for our clients. So we've put together a program that will help real estate agents understand what they should know and what they may or may not know, because as you understand, a lot of these issues are going to be site specific. So as we go through today, we're hoping to educate you on the things that are going to be universal to all HOAs and the things that may be site specific. We understand you get a lot of questions from your consumers, and our goal is to help educate you on where you can get those specific answers for your group, and of course protect yourselves in the process. So with that, I'm going to turn over to our first speaker. His name is Dave Wonkel with Iger, Wonkel & Bonkowski. He's a very successful and award-winning attorney here in Orange County and has been part of the CAI Education Committee for more than a decade. So with that, I'll turn over to our law section. David.
Thank you very much, Scott. Good morning, everybody, and welcome to our What Every Realtor Should Know About Common Interest Developments class this morning. As Scott mentioned, my name is David Wonkel. I'm an attorney with the law firm of Iger, Wonkel & Bonkowski. I have 25 years of experience practicing law and litigation related to construction, development, and real estate. And for the last 11 years, I've been exclusively practicing in the HOA arena, representing homeowners associations with respect to corporate compliance and litigation related to the aspects of an association's point of view. Couple of caveats before we get started too much here today. Please recall, although that I'm an attorney, I don't have the ability to give legal advice here today. None of you are my clients. And even if you were my clients, we would not be able to give legal advice to you individually, as there are other people in the room, and that would breach what we call the attorney-client privilege. So we try to, we will do our best to answer any questions, and we try to speak in generalities rather than in specific here today. So please, if you have any questions or you have anything you'd like to know that is specific to a particular matter that you're dealing with, of course, we can't talk specifically about that, but we can talk in generalities about the issues related to them. So that being said, we'll go ahead and get started here today about the things we're going to be talking about. I'll take over the first hour here this morning, and we're going to be talking about the various aspects of the law and what you need to know as far as a realtor is concerned related to our CIDs. And when we say CIDs, that is common interest developments. Our first slide is probably one that you hopefully are familiar with as either a realtor or a broker, and that's Easton versus Strasburger, and that's the main and seminal case in your field that deals with the idea of what your duties are as a realtor and a broker when it comes to advising your clients as to the aspects of a common interest development. Today's real estate world, I don't know the specifics as far as the relationship between the number of properties that you might sell as an individual broker versus those that are actually in HOAs, but I gather that you're probably doing the majority of your single family home sales through, and certainly condos, through homeowners associations. When you're dealing with those, you have just these specific duties laid out in Easton versus Strasburger related to the idea that you are required to do a reasonably competent and diligent inspection of the property and letting your potential buyers know all of the things that you as the broker might be able to identify reasonably and competently through an inspection. Now, what does that mean specifically? Obviously, your duties, etc., are laid out within that case as to what they are. And of course, this case was decided in 1984, and there's plenty of progeny since then that would give you specifics as to what you need to do and what you don't need to do. But for the most part, What you need to understand here for what we're talking about here today is that your duties relate to the unit that you are selling. If you are in a condominium community or in a planned development, it's the particular property that you're dealing with. You are not necessarily required to go into the aspects of what the common area elements are and any of those types of things and issues related to them. Although if you do have specific knowledge of those things, you cannot withhold it. So here we talk about the idea that if a broker knows or should have known through a competent inspection about a particular issue and does not disclose it, that broker and the real estate agent can be held personally liable to the buyers when those issues come up. So some of the things that we're talking about here today are those things that you need to understand in order to make that proper disclosure to your potential buyers through your sellers. And as a buyer's broker, the things that you want to know to be able to tell your clients as to what this property is not, and who's responsible for what. So all of these things that we talk about with Easton versus Strasburg are set forth, and generally speaking, in California Civil Code section 2079. And that has to do with the brokers and the salespersons licensed under Division 4 of the California Civil Code and the Business and Professions Codes. So things to consider are listed here on the screen. You have to make an effort to ensure that your clients have copies of all of the documents related to HOAs. And we'll talk a little bit about that as we go as to what those are. You have to make an effort to ensure that your clients understand what the use restrictions are and the community policies, such as like a list here, parking, personal items, decorations, and some of the things that we see that aren't necessarily listed here, but the various use restrictions and architectural restrictions. In today's environment, we see a lot of flippers coming into these properties. When I say flippers, I don't mean that in a derogatory sense, but the idea that a property owner would come in, buy a property, remodel it immediately, and then put it back on the market for sale. What you find when they do that in an HOA, of course, is that you are restricted on a lot of things you can do with regard to remodels. And because they are trying to act so quickly, and because of the nature of the architectural approval process through an HOA, you may run into problems. You need to make sure that they identify those things before they purchase, so they know what they're limited to and what they can and cannot do with respect to architectural applications. You need to make an effort to ensure that your clients understand the financial conditions of the HOA. We'll get into much more of that as you go with regard to the finances. That's not my area of expertise, but you will be talking to from or hearing from other speakers this morning about the finances of an association and how to read those and what they're going to say for you. And of course, we recommend you consult with a licensed and insured insurance agent so that you understand exactly what insurance the HOA has and what the individual owner needs to have as far as protecting their property and in some instances, the common areas of properties that they may be adjacent to. So with that, we'll talk about the definition of what the different types of common interest developments are. Generally speaking, in California, there are 4 types, although 2 are the most prevalent. The first 2 we'll talk about are here. We'll talk about them specifically because you're going to probably run into them 95% of the time when you talk about common interest developments. The first ones are condominiums. Condominium is a legal form of ownership. This means that basically what you're looking at is an individual owns what is defined as a unit. For the most part, although things have changed quite a bit recently with different types of condominiums, but for the most part, we talk about what we know as airspace condominiums. Essentially meaning that if you take a wine box and you take the interior of you take the wine out of the wine box and you take the individual cardboard sleeves out of the wine box, you have an empty shell of that wine box. The interior of that, the air that's inside that wine box, is what the individual owns. Now, when you put the cardboard sleeve back in, that divides the rooms back up, like you would dividing the airspace for the wine. You put the cardboard sleeve back in, that's the individual rooms within your unit. And those are that individual sleeve that can be removed and dropped in. That would be the individual owner's part of the unit. But the cardboard exterior, the cardboard box roof, and the cardboard box floor, that is all what we would consider common area. It's made up of, all of those things are generally made up of 3 components. The piece of cardboard that's on the interior, there's a piece of cardboard on the exterior, and then there's corrugated cardboard in between. If you think of that in the way that a wall is made, you think of the drywall on the inside, you think of the stucco on the outside, or wood siding, or whatever it might be, and then on the inside are the studs that hold that wall together. all of that component for those exterior walls in an airspace condo is typically common area. That includes the ceiling, and it often includes the floor, although the floor is usually either a concrete slab or it's made up, if you're on an upper floor and a lower floor, the in-between area there. All of those things are common area. The remainder of the interior, the air on the inside, and those corrugated differences changing the rooms out, there'll be your interior walls and anything you put inside there, including the idea that you don't want to look at the cardboard wall when you're living in your unit. You want to paint that wall to make it look like something that you want to have decorated. That paint is yours. When I say yours, of course, I'm talking about the unit owner. So that's what an airspace unit in a condominium means. You own the airspace, you own the interior. As a group, all of the owners combined, sometimes in phases, sometimes as an entire community, own the common area in common. That's why it's called common area. Ultimately, this consists of buildings. It can consist of single family homes, those sorts of things. We'll talk more about that. But that's generally speaking what a condominium is. The second type of ownership is what we consider a planned development. Usually a planned development is the ownership interest in a piece of land and the structure that is on that land. Different from a condominium, mind you. The individual owner in a condominium owns airspace, what is inside the unit. In a planned development, typically an owner owns the actual land itself and the structure on that land. The common areas might be those areas that the individual association as a corporation owns, the streets, the slopes, different types of areas of this nature. The association physically owns them in the form of a deed to where it is their ownership interest that has that. In a condominium, you might also have the association own portions of common area, such as the clubhouse where the pool is, things of that nature. Those might be lots that the association owns, but in a planned development, the association doesn't have an ownership interest in the individual lots that are owned by the homeowners. Now, again, that doesn't mean that the association isn't responsible for things like roofs, landscaping, slope maintenance, all of those sorts of things, which we'll talk about later. But at the end of the day, the difference between a condominium and a planned development. In a planned development, the individual owns the land and the structure. In a condominium, the land and the structure is owned in common, and the individual owns the airspace unit inside. And again, those can be different based upon other things. You need to understand what the differences are with your particular community. There are two types of other ownership in California. One's a community apartment project, and the other's a stock cooperative. They operate similarly, whereas in a stock cooperative, there's a corporation that owns the entirety of everything in the area. And then each individual owner has a certificate, a stock certificate, like a share. And that share entitles them to occupy a particular unit within the community. In a community apartment project, usually it's an association similar to a condominium, but the entirety of the project is owned in common by everybody. And then each individual, instead of owning their separate airspace, they have the right to occupy and lease a particular apartment within that building. So they don't necessarily own the airspace, they have the right to occupy that airspace. But the entirety of the building itself is owned in common. These are less common in California. You see them much more common back east. But these do exist out here, and you need to watch out for them. They're usually much older. We don't usually create them new today, or they might be what we consider conversions. Long Beach has a lot of community apartment project conversions that have now been converted into condominiums. So common interest development types, we often see the terms used, especially in the marketing industry, whether it be for common interest developments for realtors, brokers, things of that nature. You use the term townhouse. Townhouse is not a legal term. It's not a form of ownership. It is just a description of how the unit is affixed to the property itself. So in a townhouse, typically you have an individual unit that is top to bottom owned by an individual. Side to side can be common between multiple people. So then there is also what we call stacked units. Stacked condominiums are not a legal form of ownership. It just describes the fact that there's one individual unit owner perhaps below and another individual owner which owns the unit above. So those would be stacked in order. Townhouses are typically side to side. Stacked are typically up and down. So those things do not describe anything other than the fact of how they are configured for purposes of marketing so that the individual buyer might understand what they are. Again, single family attached or single family detached, these are not forms of legal ownership. Just because a house might look like the one down on the screen down here in the right-hand corner doesn't mean that it isn't condominium. Now, it's generally speaking, it's rare that it's not. It's usually a planned development. They usually own the land with it, but that doesn't mean, we see more and more of this today where developers are attempting to get around the minimum restrictions for sizing by creating condominiums that have what are called a canopy above them, a common area, where the individual it's a condominium, but it looks and feels like a planned development where it's a single family home detached. So you need to be careful about understanding, as a realtor and as a broker, understand what it is you're actually selling. Is this a condominium? What is the ownership interest of each person? And of course, knowing that, the only way to understand what that is, you can't know it by looking at it. The only way to know it is to actually look at the documents and understand the distinctions between these different types of categories. Okay. So what are we dealing with when we talk about all of these issues with common interest developments? What are we dealing with? Well, when it comes to homeowners associations, common interest developments, as we call them, homeowners associations, as you might call them, or HOAs, there is a very specific set of laws that deal with HOAs and pretty much only HOAs. So for those of us that are specialists in this field, whether it be CAI or the various vendors that deal with common interest developments as a practice and as a profession, we deal specifically with the Common Interest Development Act, which is the Davis-Sterling Act. And that's codified in Civil Code sections 4,000 and through into the 6,000s. So what you need to understand from a broker is that there is a very specific set of laws that deal with common interest developments, and you need to recognize that those laws apply differently than they do to other types of real estate, other types of law areas, and we have specific laws related just to us. And that has to do with all of these various things that are listed here, whether it be maintenance, assessments, individual rights, corporation rights, who maintains what, how they maintain it, the responsibilities of architectural issues, and all the things that come with that are all dealt with in the Davis-Sterling Common Interest Development Act. And that's where we look to first to find out. Now, when the Davis-Sterling Act doesn't describe the particular issue, there are plenty of other laws that do. And you can find those sources. One of the major sources that we look to, both as lawyers and as other types of industry people within the common interest development world, is the Condominium Blue Book. It contains a copy of the Davis-Sterling Act along with cases and other sets of laws like the corporate laws and the federal laws dealing with the various issues you might encounter. This is a great book to have on hand. I keep one in my briefcase. Whenever I go to a homeowner association meeting, I can whip it out really quick and find the particular law that deals with the particular topic we're discussing. We can get through that. It's a great idea to have one on hand at your office or in your briefcase, so that if something comes up and you don't know the answer, you can look it up quickly within this book, and it will help you greatly. So other than the Davis-Sterling Act, when the Davis-Sterling Act doesn't necessarily describe all of the details on how a particular corporation works, that's when we get to these things like the Corporations Code. The Corporations Code is going to tell us all the various aspects, for the most part, on how your HOA is going to be operated. So what you look to is the various different aspects of the governing documents. When it comes to the law, the Davis-Sterling Act deals with how we handle things particularly, and of course, most of your HOAs, vast majority of them, are going to be known as corporations. So because they're corporations, just like any other, they're subject to the same obligations that corporations are across the board. We are typically, when we talk about HOAs, we are mutual benefit corporations, which means there is a specific set of laws within the governing documents under Corporations Code section 700 or 7000, etc., that deal with common mutual benefit corporations. So those are the kinds of areas where you want to concentrate on when you're thinking about what to look for as far as how the corporations work. In addition to that, we have various different laws that deal with associations on a varying different levels. One of them, of course, is the Vehicle Code, And Vehicle Code Section 22658 has to deal with parking and the ability of an association to tow cars when they're parked incorrectly within an association. Knowing that particular code and what that means for a particular association is important from a board point of view and from an individual owner's point of view, to know where they can and cannot park and what their restrictions are going to be with regard to parking. Because so many people today, there's a 2-car garage, but they have 4 vehicles because they've got 2 kids in school, or they've got an extra truck or something of that nature. And of course, can the owner of the property bring his commercial vehicle that he uses for work every day and store it on site? Will it fit in the garage? Is he allowed to park it in the common area, or is he not? All of those things should be known by the brokers when they start talking to these owners about what they might do for a living and how they might impact the association's rules with respect to parking. Additionally, we have to deal with things like the health and safety code for California, various different aspects of how that works with respect to use of the common area facilities like the pools, the spas, the clubhouses, all of those different aspects, keeping things safe as far as asbestos, air quality control management, lead-based paint, all of those things all come into the health and safety code regulations, and those also apply to all of us. In addition, there's a bunch of federal laws. Americans with Disabilities Act, known as the ADA. Most of our associations don't involve the ADA because they are private property. The ADA typically applies to public property. And no, just because you don't have a fence around your common area park doesn't mean that it's necessarily open to the public. It's still private property. You might not be subject to the ADA, but then again, you might. So it's those kinds of things you'll want to look into to determine whether or not the ADA might apply. The Fair Housing Amendments Act is California's act, and the federal act that deal with the same thing as the ADA, but on a more close-knit basis with respect to housing as opposed to public access to public spaces. Bankruptcy code, of course, deals with the idea that anybody who owes association dues and can't pay them and then files bankruptcy, we have the inability to collect them through bankruptcy court unless we have liens, etc., against particular properties and how that works. And then, of course, people who don't pay their assessments are subject to the Fair Debt Collections Practices Act. And there are a number of different other acts that are out there. These are the most prevalent that we deal with on a regular basis. We also get many of our laws. There are a number of different laws related to associations that are directly related to case law. Case law is when a particular fact pattern goes before a court and a judge would make a decision based upon how the law applies to that particular fact pattern. If it's unique enough and important enough that the court feels that this is something they want to publish, they'll publish that in the form of an appellate opinion. So once it goes up on appeal and the appellate justices believe that this is something that's important, they will publish it, and then it becomes case law. So that the next time this particular issue comes up, the judges at the trial court level can look to what the appellate court decided on a particular case and apply the law and the fact pattern together to give you an understanding of how they should be working forward on determining the issues related to their case. Sometimes the cases are exactly the same. Sometimes they're much more relatable rather than exactly the same, and you can determine that. And we use them as anecdotal reference and specific what we call stare decisis. The idea that this fact pattern has already been decided by the courts and it should be decided the same for everybody. So we see a great number of these. There's hundreds of cases relating to HOAs on how they operate and what they do. And again, as we talked about at the beginning, they are different than you might find with respect to other types of community or real estate or other types of sales, whether it be commercial or anything else. You always need to be careful about whether you're dealing with residential, commercial, and whether you're dealing with CIDs, common interest developments, or other types of real estate issues that whether that the particular case might apply. So when it comes to you and your sales and what you need to know and what you need to receive from various different parties, whether it be from the association's management company, the association itself, your seller, and the things that your buyer definitely needs to know, one of those major issues is the governing documents for a common interest development. And governing documents is a general term that we use to describe a number of different things, including things like the CC&Rs, the bylaws, the rules and regulations, the tract maps, the articles of incorporation, and any other types of things that the associations might come in. I'm seeing that we may have a couple of questions. Scott, are you around to be able to take those and see if there's something that you want to? I'm not going to be able to do
I'm
this while we
responding to
go,
questions
but
now.
just want to make sure that those questions are covered.
Yes.
So for purposes of the common interest developments, the main thing you're going to want to receive and understand from a broker and a realtor is the covenants, conditions, and restrictions, also known as CC&Rs. The CC&Rs are typically put in place by the developer, although today there has been a rash of restatements of these CC&Rs over the course of the last 20 years or so, where we're trying to bring all of those old communities into the modern society with respect to how these things are worded and what they mean, what they describe, etc. So all of those things can come up in the form of, what does your CC&Rs do? Covenants, conditions, and restrictions. Covenants are those things that relate to how the property itself is managed. The covenants are the things like easements, the fact that it is a part of an HOA and a particular HOA to that effect, and all the things you can and cannot do with your property itself. The conditions are those conditions of ownership, that when you own this property, you are subject to specific issues related to that property. And then of course the restrictions are just that, things that you cannot do, the things that you are prevented from doing, or you're limited in what you're allowed to do with respect to your ownership in an HOA. Those are all contained within the CC&Rs. They're often hundreds of pages long. They are often have a great number of exhibits attached to them, including sometimes the condo plans and various different other things that are there. And so you want to make sure that you understand, again, reading them is important. Generally understanding how they work is important. You're never going to understand them specifically related to each association, but you definitely want to make sure you have a clean copy of those. And I'll talk a little bit about what that means as we go. One of the other items that, especially for condominiums, of course, and this only applies to condominiums, is having a copy of the condo plan. This is not necessarily something you're going to find in an everyday HOA, but if you have a condominium, you as a broker and a realtor should be getting a copy of the condo plan and providing that to your buyers. For purposes of understanding the condo plan, they often have definitions specific to each particular unit, what the unit consists of, and perhaps even who's responsible for maintenance of any particular item within that condominium. So it's important to understand what it is you have. So the condo plan is one of those important governing documents. With regard to a plan development, that is typically the tract map. So typically what you're going to see is in a condo, you have a condo plan. In a plan development, you have a tract map. That tract map, as you see down in the bottom right-hand corner there, I'm sure you've seen these before. These are the actual lot lines and the plan associated with easements and restrictions and things of that nature that might be related to what you own, where you own it, and exactly how it operates within the community itself. So these kinds of things are all there. They all come from the county recorder's office. All three of these things, whether it be the CC&Rs, the condo plans, and the tract maps, these are all things you get and they're recorded against the property. And changing them is difficult. Articles of incorporation, this is the formation of the corporation that is the HOA. So the association is the corporation, as we talked about before. In order to form a corporation, you have to file what's called an articles of incorporation. Sometimes these are one-page documents that just describe the fact that we're filing a corporation, we're naming it this, and this is how you get a hold of it, and it is then registered with the state of California. The others, older associations in particular, the articles of incorporation set forth all of the details of the CC&Rs. So sometimes it's important to understand that you may have an articles of incorporation that will give additional details to what your CC&Rs may have stated, or they may not, but it's important to know what they are and how they operate. So far we've been dealing with CC&Rs. They deal with the restrictions and the specific set of laws and governing issues related to the property itself. The condo plan is a description of exactly what it is everybody has and where it is owned. The tract map is the same thing, only for a planned development. Now we're talking about the Articles of Incorporation, which is a registration with the Secretary of State for the state of California, but it is not necessarily recorded against any particular property. The next one we deal with is the bylaws. A lot of people confuse bylaws and CC&Rs. You hear people talk in terms of, hey, the bylaws of this association say I have to go through the architectural committee to put up a jacuzzi in my backyard. That's misnomers, it's misunderstandings of what bylaws are. CC&Rs are probably going to tell you whether or not you're allowed to have a jacuzzi in your backyard, but the bylaws are going to tell the corporation. Bylaws are the operational documents for the corporation itself, not for necessarily for the property. CC&Rs deal with the property, bylaws deal with the corporation that is the HOA, and of course the membership interests in the HOA. So your bylaws do all the things listed here, including member discipline rights, voting rights, procedures, how the board operates, how many board members there are, when they're elected, how you go about increasing dues, the budget issues. All of those things are typically contained within your bylaws for corporate governance, not necessarily property governance. Although you do have to be careful. They do overlap. Sometimes law firms when they draft these things, they do put overlapping descriptions, both from the bylaws into the CC&Rs and from the CC&Rs into the bylaws. So you need to watch out for those conflicts that are there, but they are there. Additional sources. Now we talk a little bit about the CC&Rs, the bylaws, etc. And one of the things that always gets confused is what is a rule and a regulation related to a CC&Rs. And I use this example throughout my career to try to describe. Most of us in this audience now have been through a civics course, and we understand how our government works. We have a Constitution of the United States. The Constitution is the document that's generally basic, that has some specifics in it, but is an overarching document. Then we have, within that document, it creates a legislature that makes the laws in this country. And that would be the Senate and the House of Representatives for purposes of Congress. When those laws are created, those laws must be constitutional. If they are, as you've probably heard, a certain law may have been passed by the legislature or even by the people and voted in, ultimately it'll go through the courts, and a court might say, well, this law is unconstitutional because it's not consistent with the overarching document that is the Constitution. When it comes to an HOA, we operate in almost the exact same fashion. We just call things a little bit different. So instead of a constitution, you have the CC&Rs. The CC&Rs are the document that's overarching. It controls over everything other than the overall higher authorities of law, whether it be state, local, federal, or other types of laws. But for the most part, you have your constitution for your community. Your constitution allows your legislature, your board of directors, to create laws, what we call rules and regulations. So when you think about how this operates, your legislature, your board, makes laws, rules and regulations that must be consistent with your CC&Rs. Otherwise, they're considered unconstitutional and would be shut down by a court if we had brought a challenge to those laws because they're not consistent. So what we deal with here is rules and regulations are the laws created by the board on how the day-to-day operations of the community are run. Things like you can't park more than 72 hours versus 96 hours in a particular space. And whether or not you're allowed to paint your house blue versus gray versus pink. All of those sorts of things. Those are laws created by the board. Those can be changed at any time. The board can decide that pink is no longer a color that is good for our community. We're now going to change that to only green shades. And that would be a rule and regulation in the architectural guidelines that the board would change on at any time that they felt it was appropriate. So those are considered to be what we call laws, and they do that through the procedures set forth in the law. Sometimes procedures for rule changes are set forth in the bylaws, sometimes are set forth in the CC&Rs, but today the Davis-Sterling Act overrules all of those things, and it sets forth the particular ways in which rules can be changed, and you see those codified in 4340 through 4370 of the Civil Code. Again, rules can be changed quickly by the board. They have a 28-day rule change period where the membership must understand what's going on and what they've been offered. And then of course the board can adopt those rules, and they have to give notice within 15 days of that adoption. They become enforceable right away, but they have to give notice to the membership. Those are typically done by posting of rules at a particular location or through the mailing, email, etc. of the rules out to the members as we go. Now, why is all of those things, before we get to enforcement, why is all of that important for all of us when we talk about what these types of rules and regulations? These kinds of things are important for you because there are all of these disclosures that you're going to be providing to your buyers and your sellers at any given time. It's necessary to provide all of these documents to those folks, and they need to be correct. One of the questions we often get from brokers and real estate agents is, why do HOAs charge so much for the varying different documents that we're going to get through escrow? Why is it $1,200 to get all these documents which are in place? And can't we get them for free through the seller and that sort of thing? And the answer to that question is yes. The reason they're expensive is because there is a liability associated with the idea of providing them correctly. These things change as quickly as 28 days. So every 28 days, we may have a new set of rules in place for a particular association. The governing documents need to be a complete set, and sometimes you'll see a set of CC&Rs drafted in 1970 that has 20 different amendments to it. And a seller might have a copy of the CC&Rs. They might provide that to you as the broker or realtor, and you might then provide that to the buyer through escrow. And you might think that you're all good, you've covered yourself because, well, heck, the seller had the CC&Rs and we provided it. The trouble is the seller may not have had all 20 of the amendments that change just about everything in those CC&Rs, and you've now provided your buyer with the wrong set of documents. So the reason that it costs so much money to do that is because the management companies that run these associations are typically going to be providing those documents to you, understanding that what they're providing to you is correct, and they're giving you that assurance and insurance that that is the case. And therefore, by taking on that liability, they have to offset that cost through a fee, and that's why they're there. You can get a number of these documents. The seller can get them through the management company but not through escrow for free. However, there's no guarantee, and there is no additional liability to the association if the seller provides them to you through escrow, as opposed to, say, the management company, who is the agent for the association, that does so. So clearly, although there are ways around paying those fees, you definitely don't want to do so, because ultimately you're taking on the responsibility as the broker to ensure that the buyer is receiving the proper documents and the correct set of documents when they receive them. So you want to make sure that you're going through the proper channels so that all of those sources of authority for purposes of your HOA are in the hands of the buyer and they are all correct. Okay, enforcement. A great misunderstanding as to how HOAs enforce, the types of enforcement and things of that nature. The rules for enforcement are typically contained within the disclosures you're going to receive from the HOA. They're typically provided annually by the HOA to all of the members, and they are always put together in the form of rules and regulations and guidelines and policies that the HOA is going to follow with respect to enforcement. Sometimes they're set forth specifically in the CC&Rs or the bylaws. Sometimes they're entirely contained within the rules and regulations, but clearly you want to understand what the potential responsibilities are and what you might have as far as fines or other obligations when you violate the rules and restrictions within the community. Those things are important to understand and where they come from. There's different types and levels of enforcement. Each association has a different attitude towards specific enforcement. Some we refer to as the Gestapo HOAs. You see things like Geico commercials and the cartoons down here that tend to be a little bit overbearing, and HOAs generally get a bad rap for that in that regard. However, that's not always the case. There are plenty of associations that are excellent. They don't necessarily have that Gestapo mentality, and people for the most part can do as they please until they start affecting other people. And as you can imagine, so many rule books. If you get a rule book that's 150 pages thick with 1,000 different rules and regulations, you can kind of tell that most rules are created because of an individual incident that occurs that the board then wants to not have occur again. So they then create a rule associated with it. Sometimes those boards get overbearing, sometimes they don't. So take a look at those rules, see how overbearing your association might be, and it may affect whether or not your buyer wants to choose to buy in that community. All right. In order for an HOA to enforce its rules and regulations, as well as the other governing documents, it has to hold hearings. Hearings are essentially mini trials. They're trials before the board of directors. The board of directors is the judge of the trial. And you have the idea that what's called due process. In order to have a fine levied against someone, there must be due process. They must know the charges against them. They must have the opportunity to speak to the board about those charges and defend themselves, so to speak. And the board must be reasonable in allowing them to defend themselves and when they hear the issues related to the fines. If the board believes that the homeowner has violated the rules and it falls within something that can be fined for, then the board can enforce the governing documents through way of a fine, through the way of taking away the individual's right to vote within the community, perhaps taking away the individual's right to use the common area amenities, such as the pools, the clubhouses, the playgrounds, the parks, etc. And of course, levying of fines, which can be substantial in some of these communities. So all of those things have to occur by way of a hearing, which is governed by the law and the CC&Rs and governing documents. There may be more restrictive requirements under your particular set of rules, but 10 days is typically the minimum time a hearing notice must go out before a hearing can be held and then a fine be issued against an individual. How are we doing on time here? 9:48? I think we're doing all right. So in the regards to the enforcement, informal dispute resolution, IDR, this is an area where if there is a dispute between the individual owner and the HOA or individual owners amongst themselves, they can request what's called informal dispute resolution with the board. The association, if an individual asks an association to conduct IDR, the association must say yes. If an HOA asks an individual to conduct, to join them for an IDR, the individual can say no. Although, you know, in the general context of things, we always hope that everybody would say yes to the idea of trying to resolve a dispute informally so that we don't end up in front of the lawyers' desks and we don't end up in court. We try to avoid that as much as we can. Even though I'm a litigator and that's what I do for a living, I don't necessarily like to make money off of my clients based upon court issues. I would much rather have all these things resolved in informal ways where everybody tends to get along and we don't start getting into tens, 50s, hundreds of thousands of dollars worth of legal fees associated with whether or not someone should be smoking the way they do on their patio that's disturbing their neighbors. So these kinds of things, informal dispute resolution can be put together. Each association should have a IDR policy that describes how you can request IDR and what you can do with it and how it can work. Those things are typically put forth in the annual disclosures, and they should be put forth in the disclosures you're going to be providing to your buyers with respect to the IDR policy. After we talk about IDR, the other aspect is ADR. Before a lawsuit can be filed for purpose of enforcement of governing documents that don't include a lot of money, typically the amount of money is set forth by way of the small claims court. So if it's above $10,000 on the individual side or it's above $5,000 on the corporation side, you can typically, you must typically do alternative dispute resolution before you go to court. ADR, alternative dispute resolution, is typically one of two things: mediation or arbitration. Almost always, in fact, I don't know too many attorneys in our industry who have ever done arbitrations related to an HOA dispute before filing a lawsuit. Sometimes those occur after filing a lawsuit, and they're usually related to things like construction defect. But when it comes to corporate compliance and those sorts of things, it's very rare to see an arbitration because there's, well, two aspects, and they're both listed there: binding versus non-binding arbitration. A binding arbitration is one where the decision of the arbitrator, the judge, you hold a mini trial. It's a private trial in front of a private judge. That trial judge gives a ruling. And as long as that ruling isn't so far off the rails that another court might find it to be either fraud or somehow otherwise wrong, it's binding on the parties. In other words, you don't have the rights to an appeal, and ultimately whatever that judge decides is the ruling for that particular issue. We as lawyers in industry, we typically avoid that because the association, me being a fiduciary to its members, we don't like giving up rights before we know what the outcome is going to be. So by giving the judge the opportunity to bind the association to a particular set of rules, whether they follow the law or not, giving up its rights to an appeal, we avoid that if we can. Now, what's the alternative to binding arbitration? Well, that of course would be non-binding arbitration. Non-binding arbitration is terrific. It gets the exact same thing done and the judge gives a ruling. And if either party doesn't like it, you can appeal it, so to speak, by simply going to court. Well, the reason we don't like non-binding arbitration is because it's essentially a waste of time. Usually when you're going into these sorts of things and you plan on going to court, you want a ruling that's going to have some level of effect. It's going to follow the law, it's going to have a ruling, and somebody's going to win or lose. And when that occurs, if the other side in non-binding arbitration, if the other side doesn't like the outcome, they just simply don't follow it, and we end up going to court anyway. So that private mini trial that you just did is kind of a waste of time and effort and money because you're still going to court anyway. So instead of using arbitration for our dispute resolutions, we almost always do mediation, which is a glorified settlement conference where the parties get together with a third party who goes back and forth between the two parties trying to find a mutual resolution that can work for purposes of settling a particular issue. And that's ultimately what we do before you end up in court. Of course, that doesn't always end there. We often have lawsuits. There's, for us litigators in the HOA world, we're in court regularly dealing with all of the various different aspects of temporary restraining orders, preliminary and permanent injunctions, real damages, and then what we call declaratory relief, which is a controversy. One I literally did last Monday, a week ago today. I asked the court to determine whether the association had the right to enter into someone's unit to fix a wall, common area wall, where there was mold and mildew on it. The homeowner refused to allow entry because they felt as though if they were going to, that the association had to fix anything that was damaged within the unit. The association said, no, we're going in and we're going to find out what's wrong and we're going to fix the common area. And if there's any problem with your particular property inside your unit, you're going to have to pay for it. The dispute went all the way to trial. We had a judge come down on Monday and said, no, the association is allowed to go in. They do have the right to go in without paying for all of the various damages they're going to find. They have to pay for their common area, but they don't necessarily have to pay for damages to the individual's cabinets, countertops, flooring, and personal property that might be damaged also. And that was the result that we got, and it was necessary to actually go to a lawsuit. Now, it's kind of a bummer because the homeowner in that case is going to likely have to pay something above $50,000 towards $80,000 in attorney's fees to the association that the association incurred in order to get to that point. And it was all over whether or not they could avoid about $10,000 in damages to their cabinets once they found out whether or not that wall needed to be replaced by the HOA. So it's those sorts of issues that come up that we end up in court with over all the time, and it's an unfortunate circumstance. And I think, if I'm not mistaken, the biggest issue when it comes to these kinds of cases is legal fees. As I mentioned in that case, we went to court last Monday in trial in front of a judge with witnesses and everything. Through COVID, it's a little bit different. We were partially online. We started the trial online, just like we are right now. Then we went to court in the afternoon to actually do document authentication. And then we finished the trial online again later that afternoon by way of a Zoom meeting for witnesses, et cetera, and the final arguments before the court. But what it came down to, the association was suing the individual for access into the interior of the home. We were not asking for money. We didn't ask for any damages associated with getting in there. We simply wanted to access the unit. The owner wouldn't let us. Now, the reason we couldn't settle the case, the owner kept saying, I'll let you in as long as you agree to not charge any attorney's fees. Well, by the time he said that, the association had incurred about $25,000 in attorney's fees. And for basically filing the lawsuit, doing all the discovery and getting to the point where we were ready to win the case, he then said, okay, I'll let you in. But the HOA then couldn't settle the case without asking him to pay the $25,000 in fees. He refused. So we went to trial, not necessarily on money at all. We only went to trial on the real issue, which was access. But what drove the case to trial was the legal fees. And in so many circumstances, the law, as well as your governing documents in associations, allow the winner in a particular case to recover their attorney's fees and costs. And those can be enormous. I've seen HOA cases where the legal fees and costs exceed $1 million per side as it goes up through appeals, etc. Usually when you get in a trial court setting on an issue that is general in nature, it's not something super specific or super angry between the parties, you're typically going to run between $50,000 and $150,000 in attorney's fees on the HOA's part to get to a trial. I have seen them more, I have charged more. We've had cases go to the $250,000 size as far as attorney's fees go to get to trial, and I've seen them for less. We've done them for $12,000, $15,000, $25,000 at times if there's no real dispute. But the issue that really comes up a lot, the one that we really have to consider here, is the disputes in HOAs are often driven by the costs. And those are typically the legal fees associated with filing the lawsuit, enforcing the lawsuit, and then winning the lawsuit, whether it be on one side or the other. Typically, when a homeowner files a dispute against an HOA, they also want to recover their fees. If they win in court, they will be able to get them from the HOA, so they want them before they settle as well. So we often run into this issue. It's the driving factor for settlement of these disputes. All right, defenses to enforcement, there's a lot of them out there. When the HOA tries to enforce against a particular owner, or an owner tries to enforce against an HOA for the particular restrictions on the governing documents, all of these various different legal challenges come up as to whether or not the enforcement action is legitimate. Latches, waiver, estoppel, all of those things come into play. I don't really want to go into detail on what those mean and how they work, but you understand that there are a lot of defenses out there that can be claimed. Even when an HOA decides it wants to try to enforce something, these things can be levied against them to prevent them from doing so. And so many times today, number 6 there, discrimination, we see that raised a great deal in today's environment, where if someone believes that we're putting a note on their car that they're parked in front of their house each night when they're not supposed to, they immediately scream discrimination when they don't see the same notice placed on other cars, even though what they don't know is those other cars have received notices, or they're on exemption lists or some sort of safe list. But we often see discrimination thrown around as the nom de jour of what it is that they're going to be claiming to prevent enforcement. Lack of notice of rules comes up a lot too. I didn't know is often the issue. And you probably understand, if you're an adult in our society, that I didn't know the law is not an excuse. You are required to know the law in the same way when you're driving down the road and you didn't know that you couldn't do 65 and a 55. You're required to know whether or not the rules allow you to park in a particular place or do anything in particular within your association, whether you actually know about it or not. Now, the lack of notice means if the association didn't provide proper notice when in adopting these rules, that might come into play, but otherwise you don't have the I didn't know excuse. Conflicts between the governing documents is another one that comes up often. That's again what we talk about being the concept of a rule that was made by the board that is unconstitutional, right? Is inconsistent with the CC&Rs. That's where conflicts of governing documents come in. Which one applies? Well, the one that's most important, which is the CC&Rs, and is recorded, that's the one that controls. It will rule over anything else that's done as far as like rules and regulations or other policies. Standards of care. Almost all decisions that an HOA makes within its board of directors and how they operate, they must follow what is generally considered to be the business judgment rule. That's these 3 aspects here. And there's a 4th one that kind of applies in there. That last reasonably prudent person standard is considered the 4th element. But 1, they have to act in good faith. They can't be doing this to be mean to somebody or evil to somebody or treat people differently. They have to act after reasonable inquiry investigation. That means that if the board of directors doesn't know why a slope failed, they need to hire somebody to find out why the slope failed. If they don't know what proper insurance they should be getting for the association, they should be hiring somebody to tell them. If they don't know whether or not their roofs need to be replaced within the next 5 years, they probably need to hire somebody who can tell them that. That's a proper investigation, and that's a duty of the board of directors to inquire and investigate as to the proper aspects of their management of the community. And lastly, all of their decisions need to be made in what they consider to be the best interests of the community as a whole, not as it relates to an individual. What I'll often hear is board of directors say, look, we've got all of these costs coming up this year. We have a budget set. It's going to be $420 per month per unit. We really need to increase that to $450 a month. But Mrs. Johnson, who lives in unit 212, is on a fixed income and she can't afford $30 more per month. So therefore, we really shouldn't do that to her. She could lose her house. We're going to go ahead and keep the dues at $420 and not raise them to $450. That decision is a bad decision because it is making the board of directors is making a decision based upon Mrs. Johnson and her individual issues related to whether she can pay the monies. The board needs to make the decisions on what's in the best interest of the community as a whole, since the board needs to raise dues to $450 because the community needs to be operated at that proper level. They should be making the decision to raise those dues regardless of how it affects individuals. So those are the kinds of standards that we consider. The other thing is the reasonably prudent person standard. All of these things, you must act in good faith as a reasonably prudent person would. You must act after reasonable inquiry and investigation that a reasonably prudent person would investigate. And you must act in the best interest of the community as a whole, considering that you're a reasonably prudent person when it comes to that. You can't act as, although you believe it's the right thing to do, you don't care whether you're going to do this, and you're listening to the wrong person. You know this person's wrong when they're telling you about the slope failure, and you're doing it because Mrs. Johnson can't afford it. All of those things are not reasonably prudent. And most normal people would not approve it that way, and that's where we run into that issue. And then the deference standard. The deference standard is what we refer to as judicial deference. What that means is the judges, the judicial, defer their decisions. Deference. So we have judicial deference to the board of directors. Judges defer their decisions to the board, regardless of whether the board was correct or wrong. If they were wrong or right, doesn't matter. If they made their decision based in good faith, after reasonable inquiry, in the best interest of the community, judges will not hold them to making bad decisions because they followed the business judgment rule, even if they were wrong. So if they don't follow these rules, the judge will step in and say, I'm not giving you judicial deference. Your decision was bad because you didn't follow the business judgment rule. Therefore, my decision operates. So that's where we get into this concept of how much authority does the board have to make these decisions? Even though a judge might make a different decision under the same circumstances, if they follow these rules, the board will be protected from liability when it comes time for a lawsuit. Okay, so I think I may or may not be on time, but that is the extent of my description today.
You are on time.
All the law issues, and we'll talk about finances next. So bring it back. I'll let go of the slideshow. And Scott, I'm not sure who is who our next
Eric Rivera with Manhattan Pacific Management will be doing our finance section.
Terrific.
Good morning.
Thanks, Eric. Take it away.
Sounds good. And then someone has control of the slide, correct?
Do you have it up on? Can you pull it up on your screen, Eric? If not, I'm sure we could have somebody from CAI do that.
Staff can do it if you.
Yeah, let's go ahead staff do it because it's not giving me control.
So what I was doing there, because the slideshow was on my screen, so I was sharing it and I was in control.
1 second while I pull it up.
Sure.
Do you know what slide you were on?
I think it's you'll be on starting on number 30, I believe.
Yeah, I believe it's
Got
30.
it.
Correct. Slide 30.
Great. Thank you, Brandon. Good morning. My name is Eric Rivera with Manhattan Pacific Management. We are a full service HOA firm. So you'll get your finance MBA in the next 5 minutes. So we'll get started here. Of course, one of the biggest responsibilities of the board of directors is the financial management, or the oversight of the financial management of their community. They have the duty to levy and collect assessments. This allows them to operate the day-to-day functions such as landscaping, insurance, general maintenance, and capital projects. They are given the source of duty through the governing documents, the CC&Rs, and of course by law through civil code, Davis-Sterling Act. They have a duty to manage the HOA finances through fiduciary duty. The board should be reviewing these financials monthly. Most management companies, if not all, at least in the state of California, will be sending out these board packets monthly for the board review and approval. Of course, this is something you also receive in your seller's packet, disclosure packets as well. The basic financial statements that are included: balance sheet, income and expense report, your check register, of course the general ledger, detail, your reconciliation report, and that's of course the reconciliation between the bank accounts. Both bank accounts should not be commingled, and that includes the operating and reserve accounts. Your journal entry reports, of course the prepaid reports, and then most importantly for a lot of financing, of course, is your delinquency report. That's something that most realtors and escrow like to pay attention to. Probably the next most important financial document that the realtors seek out is the operating budget. This allows the needs, policies, and goals of the HOA for the fiscal year, the anticipated income, anticipated expenses, and then of course the reserve fund allocation. Usually this allocation is determined by a professional reserve study, which we'll of course be speaking about later. What must be in the operating budget? Your estimated revenue and expenses, which should be on an accrual basis, and then of course your reserve funding as well. When it comes down to the annual assessments, the board is limited in what they can do. They cannot increase the budget more than 20% without membership approval. I know that's a concern I saw some questions on that earlier.
Eric, excuse me, I don't think your slides are advancing on the Zoom. There we go.
Yeah, Eric, can you let me know when to change slides?
Yeah, so we should be on
slide 35 right now.
35, yeah. Looks like. You got it, Brandon?
Got it? All right, just let me know.
Now the board can implement special assessment increases up to 5% of the budgeted gross expenses for the current fiscal year without the membership approval. We see that happen. And then of course, emergency special assessments are unlimited. However, this must follow the parameters within the Davis-Sterling Act. California, the board has the opportunity to borrow from reserves. However, California Civil Code 5510, the board of directors shall not expend funds designated as reserve funds for any purpose other than the repair, restoration, replacement, or maintenance of components for which the reserve fund was established. And then of course, however, the board may authorize the temporary transfer of monies to meet short-term cash flow requirements, but this does require payments within the 12 months, and this can be found in California Civil Code 5515. Go ahead, Brandon. Of course, with your annual reports, the membership does receive the annual policy statements, annual budget reporting, and the year-end financial reports that is disclosed by management or the board if it's self-managed to the membership annually. Go ahead, Brandon. And then, of course, the timelines for the annual policy statement, 30 to 90 days before the end of its fiscal year. This includes policies, enforcement, HOA maintenance, insurance, contracts, things like that. It should also include annual budget report, goes out 30 to 90 days before the end of the fiscal year. This includes the pro forma operating budget, reserve study, funding plan, financial statements, reports, all that fun stuff. Now they have the opportunity of issuing either a full report or a summary. Of course, the membership can request the full document at any time from management. Year-end financial reports should be within 120 days after the close of each fiscal year, if the gross income exceeds 75,000. And this should be, it's recommended that this is done by a California licensed CPA. And then with that, this exciting information, we'll go ahead and lead into, I believe it's insurance with Corey
Neubauer with Roy Pelosios Insurance. And I believe Corey's going to be helped by his wife today.
Everyone.
Hi, everyone. Good morning. Thanks for taking the time to meet with us. My name is Corey Neubauer, and this is Tina Neubauer, and we're with Roy Pelosios Insurance. We're an insurance agency here in Laguna Hills, California. We specialize in HOA insurance and have been in business for a good 25 plus years. Almost 30. And we have probably about 500 associations throughout California, so we're very familiar with all the rules and regulations. So let me see if I can flip over and get our slide deck going. So give us just 1 second here. Someone might need to unshare the screen, if you could. Bear with me. Can everyone see that now?
We good?
Yep, we can see it.
We can see it? Okay. All right, guys. So I'm going to be kind of discussing insurance, and I'm going to try to keep this 10,000 foot level for you guys because we all love insurance. So basically, why do we need to buy insurance? Well, obviously the lenders, when we're in the process of escrow, require that the property that's being purchased or refinanced be insured. And then we always wonder, well, what dictates the requirement for HOA insurance? Well, the CC&Rs, or the governing documents, have a specific section within their this large 100+ page document that stipulates what type of insurance, what limits, what extent of interior coverage, or only common areas that are supposed to be covered. Next slide. So what is insurance? So basically it's a transfer of risk. So for a fee, you're paying the insurance carrier a fee, and you're going to transfer the risk that you have, your property, if something happens to it, the real property in the community, the liability in the common areas. You're transferring that risk on over to the insurance company, and they will accept the risk, underwrite it, and accept the risk. And that's pretty much what the purpose of the insurance is. Next slide. Now we get to the main parts of kind of the insurance. We have the property section. This is also known as first property, or things that, or HOA property, in the sense of, I'll try and keep this as much to HOA as possible. So first party property damage would include the interior or buildings of a condominium association, things that you can touch, any common areas, let's just say a rec facility, any shrubbery, anything to the common areas, or anything that in a condominium like the building would be considered first property, or items that we would insure against. And a lot of the times when we think of perils, which are what are the causes that are covered, typically it's sudden and accidental causes, fire, wind, hail, there could be water damage for sudden and accidental discharges of water. It's typically the ensuing damage. There's also liability in insurance as well. This would be for people that fall within the common areas, in this case, hurt feelings, which happens a lot in California. So those types of things would cover the association against the liability. Limits and deductibles. So in a property insurance, I just want to make this really clear because we get calls in our office all the time from lenders saying there's not enough insurance. When an insurance company develops their limits on a property insurance policy, they run the property square footages, all that such through a program called Marshall and Swift, or a BVS, which is a building valuation system. They put in all the particulars, the building characteristics, and that system spits out a figure, and that's the replacement cost to rebuild the property. So while the property may be selling for $1 million, it may only cost a fraction of that to replace because we don't insure land, and we don't factor that in. So remember, a property near the coast is going to be substantially more. That same exact property in the desert, it's the same property, the reconstruction costs are the same, but again, the price difference is substantial. So when we are insuring something, we're insuring the cost to replace. Now deductibles, again, the limits are chosen usually by the carrier. The deductibles is what the consumer or the HOA has the ability to decide. Some governing documents do have limitations on the amount, the caps that they're allowed to have, but usually the associations are encouraged to carry a little higher deductibles in order to mitigate and offset some of the costs, because insurance, it can be a substantial line item in an association's financials. Now we've got the types of property coverage. So we all know that fire insurance is for the structure. We'll take for condominiums, for example. Fire and then the fidelity bond, those are typically required coverages that the association must maintain and carry, and they are paid through by the members' assessments. Earthquake insurance is really a catastrophic and is optional. Some HOAs carry it, some don't, because the cost can be quite prohibitive to membership. Flood insurance, that one's a little different. Flood is typically dictated by, there's FEMA, and a lot of the lenders will run flood zone determinations on the property, and they will dictate, hey, this property is in a flood zone, and it is required. So fire fidelity usually is required by the governing documents. Earthquake is optional, and flood, typically, if you are in a flood zone and it is required, you carry it. But if you're not in a flood zone, typically it's not carried because, again, it can too also be cost prohibitive. Next slide. So now we have the general liability. General liability are for kind of more or less the common areas in the community. So, for example, any common area amenities, whether it's a community gym, a pool facility, any tot lots, those types of things, those were the general liability, or if someone gets hurt during those, while they're using those said amenities. The D&O, directors and officers, that is for board members and property management companies for any poor decisions that they may make, or an error or an omission that they may make in the course of running the community. Medical expenses under a general liability is a no-fault provision. So for example, somebody gets hurt in the common areas. I'll give you an example. I had a lady, she was sitting on the edge of a pool chair, pool chair, and she put all of her weight on the end and she fell flat on her behind. Well, she knew what to do. She went to the doctors. She went ahead and said, I want my medical bills paid. But because it's a no-fault provision, just because the association's policy pays it, doesn't mean that they're accepting liability for her injuries. But she knew enough that she could get her medical bills reimbursed because the incident happened in common area property. Personal and advertising injury, you don't see it a lot in the sense of the advertising part in the association, but the personal injury would really be libel and slander. So those are those types of things that would fall under that. Umbrella or excess liability is any liability on top of the underlying, or the primary general liability. For example, if an association carries a $1 million per occurrence limit on their underlying or their primary policy, they may have a $5 million excess if something catastrophic happens and the association is deemed liable, and it exhausts the primary 1 million, that's when your umbrella policy will kick in. And then we have workers' compensation. This is really for more or less, we'll get down into this more, I think, more into the presentation as to why do HOAs need this. But workers' compensation is just for a non-payroll workers' compensation policy. So if, you know, the association is sued for workers' compensation related issues, the general liability doesn't cover the cost of defense. If you have a workers' compensation, that's where that would fall under, and it would cover board and committee members as well. And then the cyber liability coverage would pay for any privacy breach response services. So next slide. So here we go. Now we're going to kind of pivot, which is the theme of 2020. We're going to pivot and talk about HO6s. Now this is more of a personal policy, and we hear this all the time in our office, especially from lenders. You know, is this walls in and does it have an HO6? Let me make this clear that the term walls in came from, is not an insurance term. You're not going to find walls in any policy jacket or language or in an HO6 policy. Walls in is something that's relatively, I would say it's relatively new, but it's just the extent of coverage within the interiors. But we always promote and we always recommend that every homeowner, regardless, never rely on the HOA's policy and always purchase an HO6. And here, this is kind of why and why we feel that, and I'll try and give you some basic examples and reasons why. So the first part of it is personal property. If there's a fire, I'm going to use fire as the main example because it's the easiest peril that's covered across the board. If there's a fire and someone and a unit owner in a condominium has all of their personal property damaged, well, the association's policy, they're not obligated to cover property of others that is owned by others or the unit owners. So they should have a policy that would cover those personal items. And now we have the building improvements. Now, some governing documents state that just the basic declarant installed fixtures within a unit. So for example, if you have a home that's built in the 80s or the 90s, we'll use the 90s, we got the linoleum, you got your basic tile, basic component, basic component. The misconception that many homeowners get and a lot of buyers and sellers and everybody gets is that, well, the improvement was there when I bought it. So that means that the association's insurance policy covers it. Not necessarily. If the association's insurance or CC&R state that it's the original installed declarant items, whether you put it in or a subsequent or a previous owner put it in, you as the homeowner, the new owner of the property, are required to cover those said improvements. So just keep mindful. So if you have wood flooring, you know, Berber carpeting, maple cabinets, granite countertops, and the declarant did not install those in the original construction, you could be deemed responsible to insure those items. Also, you want to make sure that any deductible in the event that you are responsible as the homeowner, or if the homeowner is responsible, that they do have adequate insurance coverage to cover that portion. Some of these associations, because the insurance market is hardening and you know that they are being mindful of HOA dues, they are raising their deductibles and shifting their responsibility to the membership to cover those said. We've got quite a few on the books that are $25,000, and and some are 10, and there's definite sticker shock or shock when we get homeowners that call and want to file little claims and they realize the deductible is very large. Now there's also a personal liability component. In fact, we actually have a story. We had a person, it's not really related to an HO6, but they tried to file, we had one where they had a dog and they, I guess, had a guest within their unit, and the dog nipped at the guest, and they didn't have an HO6. So they decided that they wanted to tender it under the association's policy. Again, the association doesn't cover your personal liability. It covers the corporation's liability. So if someone falls within your unit, if you have an animal, you are responsible for all of those items. You need to make sure you have adequate insurance. Loss of use would be, we'll go back to the fire example. Say you're displaced because you can't live in your home, it's uninhabitable, and you need to go stay. In fact, we'll use the recent wildfires. We did have a couple of managers come to us and say, hey, we're being evacuated, or, I can't live in my unit because, the smoke is too much or there's fire. The association, again, the policy, they're not obligated to pay for your relocation costs. If you have an HO6, typically under that line item of coverage, you're not subject to your deductible, and you can go ahead and submit your hotel, your eating expenses, and those types of things. Now, loss assessment coverage is pretty much if the association is assessed for a covered item or that type of thing. So if you're assessed a dollar amount, say it's $10,000 per homeowner, and you don't have an HO6, you're going to probably be out of pocket yourself to pay that assessment. Now, comprehensive auto coverage, I don't know if that's necessarily something in HOA or they're just trying to tell you to make sure you have the right kind of insurance. So we'll go to the next slide on that one. Yeah, but it looks like it's a general theme. The comprehensive, you have to have it. It's required by the state of California. That's what I'll say about auto coverage. Now we're moving on to CEA, or the California Earthquake Authority. So that's run by the state. And it's got similar components to an HO6. It is a companion policy. So the CEA is not standalone. And what that means is that you have to have an HO6 in order to have a CEA. You can't just have a CEA by itself. So again, I won't go into major things. Again, it's very similar. It covers all of these items. The only caveat is that the peril is strictly earthquake, which again is not covered under a standard HO6 policy. So that's how, again, make sure you have comprehensive auto coverage. Okay, next slide. Okay, D&O, directors and officers, or errors and omissions type of coverage. This is for the if an association, any mistake that a board of director makes, they sue the association for breach of fiduciary duty or any decision making that they made. If a board member is individually named in a complaint, a lot of the times the board member will likely turn that over to the association's insurance for a response. Let's go to the next. So the talking points. So now we've got insurance talking points. Most insurance coverages, especially property and liability, are occurrence form, which means coverage is triggered once the association or you would go to the policy in which the occurrence took place. So if the event happened yesterday, you're going to go with whoever had the insurance policy yesterday. Directors and officers, let me go to another term, is what's called a claims made. So if you've had issues with somebody, our best advice is, no matter what, tender it the moment that you think it happens. It's not necessarily the policy that took place that's going to respond. It's going to be whenever the claim was made. So that's what you want to make sure you do. So if someone threatens a lawsuit today, but let's just say the event happened in the previous policy, you want to tender it to the current policy that has it on file. Negligence, pretty much negligence is, the association, if you're negligent for a liable act, you have to be legally liable for it in order for the carriers to pay. And then we have minimum limits on directors and officers and general liability. So the Davis-Sterling Act dictates that anything over 100 units has to have over a $3 million per occurrence. Anything under, it's $2 million. But there are some CC&Rs that do require higher limits. So whichever one takes precedent. So if the CC&Rs require a $5 million per occurrence, but it's only 105 units, you have to follow what the CC&R states. The property managers are usually, per their contract, required to be named as an additional insured, which they are under those policies. Now we're going back to workers' comp, because I know we briefly talked about it. Why do associations need workers' compensation? They don't have any employees. Well, there's a good reason why. I know management companies do their due diligence with vendors, but sometimes vendors may let their insurance lapse on accident and their employee gets injured while doing a landscaping or pool vendor. Or, for example, there's been stories where a landscaper decided to take a frisbee out of a tree. because somebody asked him to do it, and in the event he fell and he injured himself. Well, because his duties aren't to retrieve frisbees from trees, his insurance or his employer's insurance may not cover that, may not cover his injuries. So then who are they going to look to respond? The association's insurance. So it's a super affordable, low cost. It's just, they range anywhere from $400 a year to $600 a year for no employees. It's just something that is absolutely prudent and highly recommended that you keep. So there you go, next slide. So fidelity bond. Again, there are limits in fidelity bonds, and there are laws. So there's AB 2912, which required computer funds and transfer in fidelity bonds, and it's typically 3 months assessments plus the association's reserves. And then I know a lot of lending requirements like Fannie Mae, government lending agencies will also require that the association maintain proper fidelity bond coverage, and you just want to make sure it's going to cover these components such as the dishonesty, embezzlement, theft, social engineering, and those types of things. So that's what fidelity bond, and it is a property coverage and typically has its own deductible as well. So next slide.
That's it.
Oh, is that it?
Yeah.
Okay. I guess that's it.
Thank you very much.
Let me see if I can share my screen where we start. Everyone see that?
Yeah, we can see it.
Okay, let me pull this up and we'll go. Well, thank you all so much for paying attention thus far. We're in the home stretch here, so go ahead and stand up for a second, shake your limbs, get ready, because we're going to talk about the most important stuff, the finance, what's going to really drive that process. So let me get to the correct slide. Apologize for the quick run through. It wouldn't let me start. At the beginning. Okay, so first is the maintenance contracting aspect. The important aspect to understand is that associations have all kinds of maintenance, regular maintenance and then infrequent maintenance, such as replacing a water heater or a roof, etc. All of these contracts need to be reviewed by attorneys, legal counsel. There's all kinds of caveats in these contracts that can cause the association headaches down the road. So it's very important to make sure that the association doesn't sign, whether it be through the management company or the board itself, sign these contracts unless they've been vetted by your insurance company and or your corporate counsel. There is no provision in the physical code for not taking care of your property. So it just naturally assumes that the board is going to do whatever is necessary, i.e. increase the assessments or collect revenues in order to maintain the property. So if you should find yourself as a board allowing your property to fall in a state of disrepair, there's going to be little defense offered to you in a court of law. All right, our reserve studies. Now it's made up of two parts. One is the physical analysis. The other is the financial analysis. So the physical analysis, as the name would imply, are the components that are there present in the property, roofing, plumbing, mechanical, etc. And then the financial analysis is, okay, how much are these components going to cost? When are these costs going to be anticipated? How much do we need to set aside in order to maintain our property? So you've got the physical analysis and the financial analysis, each equally important. You have a few subcomponents. One is the component inventory. That's the listing of all of the items. And that should stay relatively stable from year to year. You have 5 water heaters. You're always going to have 5 water heaters. You may replace some, so you can adjust those based on maintenance, but the number of water heaters generally stays the same. The square footage of your roof generally stays the same. So they'll be pretty stable. Well, of course, the condition assessment will vary from year to year because, of course, it gets a year older. Maybe it's been replaced. So no matter the circumstances, it's always going to be different than it was last year. And of course, the life and evaluations, how much are these issues going to cost? So when we talk about the life and valuation estimates, it's in today's current market cost. And that's important. We're going to talk about it a little bit, but we have inflation, which increases some cost, and we have other costs that are based on volatile components, such as asphalt, right? It's based on the cost of the underlying material, which is the price of crude oil. So it can go up and down. So you have to make sure that you're using the most current cost when affecting that. It uses a few terms. One is the percent funded, and that's just a finding of the current reserve status. And it's calculated very simply. You have, say, hypothetically, a water heater. We'll say that water heater lasts 10 years and costs $1,000. So it depreciates at $100 per year. So if it is, say, 5 years old, at that point in time, you should have $500 set aside for that water heater. Not the full $1,000, because you're not expected to need that for several more years. So if you do in fact have $500 at that point in time, you are, quote, 100% funded, because you have all of the accumulated depreciation of that particular component. And then we have a funding plan, which is nothing more than a recommendation for the appropriate amount to put into your reserves. So Eric, a little bit ago, talked about the operating budget. It has, all of your expenses. So whether it be management, your utilities, landscaping, et cetera, all of those make up your operating budget. And then there's a line item, and then it says, okay, how much do you need to set aside in your reserves for ongoing maintenance in the future? And that, of course, is part of the funding plan. So the board adopts recommended amount they're going to put into their funding plan and into reserves, and they give that to the membership, which we'll talk about in just a second. So reserve study is essentially, what is the HOA responsible for? How much of it is there? What condition are they in? How long does this stuff last? How much will it cost to replace? The current status, or where they're at and their percent funded. And then the most important aspect, how does the HOA pay for it in the future? And that's through the funding plan that they adopt. Multiple types of studies. There's a full study, and like the name would imply, it includes everything. So they're going to visit the site, they're going to identify and quantify all the components, they're going to give them life evaluations, check the fund status, and produce a funding plan. And then there's what's known as an update with site visit. If you do the correct site visit, you only have to do the inventory one time. And then at that point, you move forward and you use the existing inventory and you update it. So that's why it's an update of the previous inventory, but with a site visit so that you can do the condition assessment, often called a number 2. And then we have an update without site visit, often called a number 3 or a desk consult. And that's simply where we remove the elapsed time from the component's life expectancy or reset those that have been replaced, add in the new beginning balance, the contribution rate, run it through the system, and it produces a new funding plan. So the Civil Code requires that you conduct a visual inspection at least once every 3 years. So that number 2, or the update with site visit, that must be done at least every 3 years. You have to review the study annually and provide a funding plan adopted by the board each year. So in essence, you have to have every 3 years with a site visit, and then the update without a site visit on an annual basis, so that you can produce a funding plan to put into your pro forma operating budget information that Eric talked about a moment ago. All right, the assessment reserve funding disclosure summary. You see this wonderful piece of paper here. For those of you that know Gov Hutchinson, next time you see him, you go up and give him a hug. Maybe ask him first, but go ahead and give him a hug, because he and his team put this together. Because what was happening in the early 2000s, for those that have been operating in the real estate industry for that long, there wasn't a lot of due diligence going on. So lenders weren't paying a lot of attention to who was, quote, filling out the loan applications. So people were just moving on. What would happen is people would purchase into these communities, and not too long after they would purchase, they would get hit with what's called a special assessment, which, by the way, shows you that the Civil Code is written by out-of-touch attorneys, because I've been doing this for over 20 years, met a lot of people paying these monies, and none of them really found it to be all that special. Now, they did find it to be a surprise, so I call them the surprise assessment. So people would move into these properties, they would get these surprise assessments, and they would often turn back to their real estate broker and say, hey, I would have liked to have known that. And they usually took them to small claims court, where the limits were about $10,000, and they would sue them, often successfully. So of course the realtors didn't like that, because it caused them to suffer what's known in your industry as a commission-ectomy, right? The removal of a commission. So they put this form together. So now it is virtually impossible to sue a real estate professional for the financial condition of an HOA because you were told. So if you look at these are very detailed. How much are the assessments? How much of those assessments are going to your reserve fund? Oh, by the way, are there any special assessments that have been approved? If so, let me know specifically what those are. Are you going to have enough money over the next 30 years? Yes or no? Let me know. Oh, and if the answer is no, by the way, that's fine. Just tell me very specifically in which years you're going to have the special assessments to make sure I have those monies. So you see this very detailed information is part of the real estate transaction. This is required to be attached to each pro forma operating budget in an HOA so that the real estate community can have information given to their consumers, both the sellers and the buyers, to understand the significant financial issues related to that particular association. So this is really nothing more than a 100+ page reserve study kind of condensed down into a couple pages. But this is the form that protects real estate brokers in the state of California. So thank you to Gov. Hutchinson for that. The disclosure requirements, as we mentioned earlier, the association is responsible to give the membership the funding plan that they adopted. So you can see here's a sample plan here, and it's very detailed. And by the way, almost all of this information is required in the civil code. So whatever provider you're using to produce your reserve studies, most of this information must be included in some format or another. And you see it's very detailed. Assessments, the regular, okay, fine, tell us how much they're going to be over the next 30 years. Are there going to be any special assessments? If so, tell us specifically when those are going to occur. The next line, we see we have our interest income, right? You have money in the bank and you're going to make money on that money. So we want to calculate that in. And this is just simply the interest income net of taxes. The component costs. So every year you spend money on components, or most years you spend money on components, but that will vary greatly, right? So the years that you do maybe a little paint and carpet, it's a relatively small amount. The years where you redo the roof, it's going to be a large amount. So it's very important to track your expenditures so that you can understand where the income and increases are necessary. And then you have the net receipts. Some years you bring in more money than you spend. Some years you spend more money than you bring in. So we want to keep track of that. So this tells us what our net is for each year. The cash balance at the beginning of the year and the cash balance at the end of the year. Very important to pay attention to where our current cash is. The estimated liability. So you see that 936,008. That is all of the accumulated depreciation. So a little earlier, I talked that you had the water heater and it cost $1,000 a year. So after 5 years, you'd have $500. Well, hypothetically, you've got a roof. It lasts 20 years and it's $1,500 a year. And if it's 10 years old, well, you should have $15,000 set aside. So it's just the accumulated depreciation of all of the components to that particular point in time. And of course, it will vary from property to property from year to year. So that's why you have to track it. Less the beginning balance. So, okay, this is our accumulated depreciation, but we do have some money. Where does that leave us? And in this scenario here, you see 766,110 is how much this association is underfunded. Oh my goodness, what does that mean to me? I am one of 58 units. No problem. We did that math for you. The very last line out of there is 13,209. And yes, this is required in the civil code because this is what the real estate community has used to do their job. You see, this information tells them how much they're underfunded or overfunded for those circumstances, which are rare. But in this scenario, it's $13,209 per unit. So what this is allowed to do is for the real estate community to do their job. So what happens in a typical transaction? You go through the process, you show somebody, I don't know, 600 or 700 homes over a 5 or 6 week period. They make an offer on 37 of them. You only get one through and accepted. Okay, good. We've got offer and acceptance. And then what do you get right after that? Boom. This whole torrent of disclosure documents, which includes the HOA financials, which includes this reserve study, which tells them the unfortunate news that they're underwater by $13,209 per unit. So now I can tell you in a, I'll say a buyer's market, maybe you've got a couple, they're getting divorced, they've been in the property for 30 years and they got lots of equity. You might get some movement on that $13,000. Yeah, they might be motivated to get out of there and you might get some movement on that. On the other hand, if it's a seller's market, the person's been in there a short period of time, got no equity, and they're trying to get out before the bankruptcy court rolls over them, my guess is you're not going to get much movement at all on that $13,000. The important thing is that that $13,000 is known by all parties, it's disclosed, it's negotiated, and whatever process is negotiated, it's in the transaction so people can't come back after the fact and say, hey, you didn't tell me we were upside down by this $13,000. So the reason that this information is so specific and so detailed and quite frankly repeated a number of times throughout these documents is to make sure that consumers have a clear picture of the financial condition of the HOAs they're about to purchase in. This is the summary, also required, and you can see it gets very basic information up at the top, the year that it's done, inflation factors, the interest rates, how much money you have, etc. And then it gets into more detailed analysis. So you have the reserve contribution itself, So it has an amount that the association is currently doing. And then below that, you see line G, that's the recommended amount. So the reserve analyst has taken a look at all their situation and said, okay, you guys are putting $100 a month away. Well, that's insufficient. You need to increase that to $143.63. Don't worry, we did the math for you again. That's $42.77 per member, which is a 42% increase. Now, that's an important number because if you remember a little while back, Eric was saying that the association only has authority to increase the assessments by 20%, right? So you see here that 42% increase into the contribution rate. If you go down a little bit and you see analysis of the total assessment, you see that their total assessment is $30,000 a year, or $521. So what we're saying is, if you take what our recommendation is, meaning the $143.63, apply it to the $521.48, you are going to have to put your assessments at 8.2% increase. See that line item in? So 19.3% will be of your assessments going to reserves. For those that work in FHA, know that's an important number because FHA requires at least 10% of the portion of the the assessments go to the reserve fund. So you're above that 10%, and in this scenario here, you need to increase the assessments by 8% in order to effectuate that $42 increase to that. Now, this doesn't take into account any increases that might be necessary for the operating budget. So if your insurance has gone up, your landscaping contract, utilities, then it might need to go up more than that amount. This just reflects to the reserve amount by itself. And then you see back down below that overage deficit again. We give you that information one more time. Then below that, there's a number there that's used for the lending institutions of the world. Again, they like to take a look at these, say, hey, is it a good idea to loan somebody money to buy a unit in this? Let's take a look at their profile. So you see that line item there says the funds to cover the cost of components that need to be replaced in the next 5 years, and it's $483,682. Okay, so they can quickly look at that and say, okay, in 5 years they need $483,000. Boom, go back up to the top. D, beginning reserve balance is $169,000. So clearly they're going to have to increase their revenue in order to meet these obligations. So in this scenario, a lender would have to take a deeper dive into this reserve study to see their circumstances. If the beginning balance was above that 483, then they could literally approve the loan just by looking at it because they understand there's no risk of a special assessment for that particular association. So you see all this information, very detailed, but it's there for a reason so that the appropriate people can look upon it and rely upon it. Although there's, I think at last count, about 30 certified reserve analysts in the state of California. So despite our small numbers, we still have one of the largest lobbyists organizations in the state of California. You guys might be familiar with them. It's called the California Association of Realtors. Yeah, they lobby and they put requirements into the civil code that require you to buy a reserve study. So in spite of that, there are still a few exceptions that we will be working on. But right now, if your association does not have a common area, you're not required to have a reserve study. If you are industrial or commercially zoned, you are not required to have a reserve study, and you're exempt from the Davis-Sturgeon Act stuff that we're talking about now. And then if your major components are equal to or greater than 1/2 of your gross budget. What that means is if you have, say, hypothetically $100,000 in expenses per year, that's your gross budget. If all of your components added up are less than $50,000, you don't have to have a reserve study because it's such a small amount. That generally would be to a small PUD or something. Maybe they have a small pocket park. The rest of the community is all homeowner maintained, so they don't have a lot of assets. So again, that's put in there as kind of a relief for the small associations. I know a lot of you deal with smaller associations, 3, 5, 8, 10 units, and some of the burdensome aspects of the Davis-Sturgeon Act can be problematic. So there is some relief for those small associations out there that don't have those specifics. All right, the calculation methodology is pretty simple. So you take a component. In this scenario here, we have a roof. The typical life expectancy is 15 years. The estimated remaining life is 5, indicating that's a 10-year-old roof. The replacement cost for this particular roof is $20,000. So our annual cost, that depreciation that we spoke of earlier, is nothing more than the cost divided by the typical useful life expectancy. So in this case, that's $20,000 divided by 15 years. Comes up to $1,333 per year in depreciation. This particular roof, as we mentioned, is 10 years old. So you would just simply multiply the 10 by the 1333 and say that at this point in time for this roof, we should have $13,333 set in the bank. Just below that's the water heater, last 10 years, got 5 remaining. Its cost is $1,000. Its annual cost is that $100. And because it's halfway through that, it's $500. So as you see in this scenario here, all of the replacement costs are $21,000. The annual depreciation is $1,400. And in this scenario, for this particular year, the 100% funded balance for this association is $13,833. So there's a big misconception that 100% means you have enough money to buy all of the assets. In this case, the $21,000. No, 100% funded means all of the accumulated depreciation. And in this scenario, the $13,000. Okay, who can perform reserve studies? Well, the civil code's pretty open about that. So the community manager, they can technically, obviously we would recommend it because of course they're probably not insured for it, probably don't have the expertise and don't want to accept the liability. Harry in Unit 3B is allowed to do that. Now, I will tell you that the civil code says that it must be a thorough, diligent, reasonably competent. So we're gonna just discuss for a second that maybe Harry can do a thorough, diligent, reasonably competent job. But the question is, if Harry in Unit 3B is doing the job, chances are he is not insured, right? Because he doesn't make any money doing this, so why would he have insurance? So he doesn't have general liability insurance, he doesn't have errors and omissions insurance, and he probably doesn't have workers' compensation insurance. So if anything were to go wrong while Harry does this reserve study, the HOA is going to be entirely responsible because they, of course, have hired the quote-unquote professional that doesn't have insurance. So always make sure you're using a competent professional that has insurance. All right, so the site visits where we look at the property, determine its physical characteristics, and do our condition assessment. Once we've done that, then we can put together the component inventory. And you see there, it's pretty detailed and it has most of the information that you're going to need. So in this scenario here, you've seen it's developed systemically. So you've got roofing, structure, paint, mechanical, etc. It highlights all of the components. It gives the approximate quantity, the useful remaining life, the current cost, the annual depreciation. So at a quick notice, you can quickly look and see what all the assets you have and what the particular costs for any of those assets might be. And then if you want to look at more information, generally speaking, they're going to have a more detailed section in the condition assessment, which often includes photographs, a detailed evaluation of what they saw, and often some maintenance tips on how to protect those particular assets. So the financial analysis is all of the life anticipated liabilities in the future, everything that wears out, and of course the income requirements that are going to be necessary. And the civil code requires that this be demonstrated over a 30-year term. So earlier we talked about it. This is that component replacement schedule. And you see we've got all the components that you see in the inventory. It's mostly a bunch of zeros because you only replace them every so often. And you'll also notice over time. So for instance, if you see that building signs, it starts at $500 and it goes to $520, $540, $562, etc. That is nothing more than inflation. So we inflate those numbers with every year. So when it comes up for due again, it will be inflated based on that. And you can see at the bottom, it tabulates that. And as we mentioned earlier, there is a lot of volatility as it relates to associations and their spending. Some associations will spend a lot of money in one year and then virtually nothing the next. As you see in this case, they've got 21,000 and 0, 123, 198. Now, the reason this is important, and particularly for those that are board members, is we often get people say, you know, the reserve study said I should have X number of dollars in the bank. We couldn't possibly spend that much money on our association today. Well, that's true because you're setting money aside. So hypothetically, if you've got a roof that lasts 30 years and it's 15 years old, well, whatever monies we've told you to set aside, you shouldn't need for 15 years. So yes, we're always going to tell you to have quote unquote more money than you need because you're not expected to spend it for a long. If you wait until the very last minute, well, then you're going to have special assessments. So we show this expenditure schedule to highlight, and every property, whether it's an HOA, commercial, industrial, et cetera, has what we call a wow year, right? And that's where the expenses just significantly outpace anything they've had ever before. So you see this particular association, it's got 21,000 and it's 0, that's a good number, right? 123, 198, 140, 101, 175. So you can see kind of a familiar pattern. They're spending about $100,000 a year, every now and then a little bit less, but let's move it out and go all the way to 2031. Look at that, $569,000, right? So that's 5 to 6 times the amount in 1 year that they're used to spending. So that's why you're saving the money, so that you don't find yourself in 2030 with half the money that you need for the next year and forced to do a special assessment. So we show these replacement schedules so that you can understand the wow year that every association has and how soon it's going to come up in your particular association. So now we do our funding analysis. So earlier we showed you that funding plan, right? And so now we simply just take our expenditure schedule and you line it right in that component cost. So you see that 210123 goes through, and now we could create a funding plan, because now without that information, you need to know how much money you do have and what your expenses are going to be. And after you have those two pieces of information, then you can start to analyze how much money you need to set aside on a regular basis to meet your liabilities. As Eric talked about a little bit before, the assessment is 20%. So the board can increase the assessments up to 20% at their own. After that, they have to go to the membership. They can also special assess 5% of the gross operating budget. Now, they can do each of those every year. So there's this misnomer that associations' hands are tied, or that they can't increase the assessments. No, that's not true. 5% isn't that much, of course. It's significant, but it's not that much. But the 20%. So let's say hypothetically in this scenario here, we've got operating expenses of $90, reserve contributions of $10. Our total assessment is $100. Okay, well, I can increase that 20%, which of course is $20. So I can increase my total compensation by 20% and then apply that to the reserve compensation like we showed before. But remember, this is compounding. So in year 1, I go from 100 to 120. Year 2, I go to 144. Year 3, I'm at 172. And guess what? In year 4, I'm at 212. So I can double my assessments in 4 years just by simply using that 20%. And quite frankly, if you're an association and you can double your assessments in 4 years and put obviously the overage into your reserve contribution to play catch up, and you still need a special assessment, I think the technical term for that is you are hosed. Yes, financially hosed. So you can see that the association, if they so choose, has the authority to increase the assessments necessary to meet their obligations. It's just that they are often unpopular decisions. And here's why. So for those who've been in management for any length of time, you've probably heard this saying, when I was on the board, we never raised the dues. Okay, that's terrific. Unfortunately, some of those people do win elections. So they serve on boards. And as we talked about earlier, they're talking about how much money they need, and they remember that they ran on the we never raised the assessment. So in this particular scenario here, we see our assessments were $100, 90 of it was the operating, and 10 was the contribution. So the next year, our assessments need to be 103, because as we all know, insurance goes up a little bit every year. Utilities go up just a little bit every year. I don't suppose anybody's gotten any relief from their landscape or other contractors. So my guess is all of your costs are going up, typically an inflation level rate around 2 to 3%. So in this scenario, they went up that 3%. So our operating expenses are now $92.40, and our reserve contribution is $10.60. Now remember, Mr. I never raised dues won the election. So the board, they adopt a funding plan that says they're only going to collect that 100 that they still collect. Now, I'll just ask you guys a question. You can think about it for yourselves. Enter in the chat box. Do any of you know what happens if you stop paying your landscaper? Okay, think about that for a moment. And I'll ask another one. Do any of you know what happens if you stop paying your insurance company? Yeah. And how about if you stop paying your management company? Well, the answer to the 3 is the same. They stop coming. They stop showing up. So of course, you're going to pay all of those expenses. You're going to pay your operating expenses because you don't want your insurance canceled. You don't want your landscaping to look ugly, and you don't want your manager to stop showing up. So you have $100, you pay your $92.40, and now what you have left over goes into reserves. So not the $10 that was recommended last year, not the $10.60 that was recommended this year, but no, $8.60, because that's simply all that you have left over. And let's see, we're going to do that one more year. Remember, this guy, he serves on the board for 2 or 3 years. So the next year, inflation hits our costs. We're up to 106%, $94.40 and $11.60 respectively. But no, we're Mr. Never Raised Dues. So we keep that same $100. We pay our $94.40 in operating expenses. And now we have simply $5.60 left over. So you can see it doesn't take but a few years of keeping the assessments at what we say current levels until you start falling behind on your reserve contributions and will have to play catch up at some point. So it often sounds like you're doing your membership a favor by, quote, keeping the assessments level. Actually, you're just kicking the can down the road and going to cost them more money in the future because they're not setting the money aside and they won't make any interest on the money they don't set aside. Okay, so what do we have to do? What does the board have to do? Well, they have to distribute copies of the funding plan that they adopt to the membership. So whatever plan they adopt, it's fine and dandy. They just have to give that to the membership. That's their requirement. They also are required to give this fine piece of paper. Remember, we talked about this earlier. This is what saves the association, the real estate community that dreaded commissionectomy. Now, I will tell you that there's, of course, situations where they don't have a reserve study. And so in those scenarios, what happens, and you all know your California CAR forms well, there's just simply a waiver that says, yeah, I know a reserve study is a very important financial document and will help me make an informed decision on this purchase. However, this particular association does not have one, so I'm going to sign this waiver that says, I know that, but man, this is a really cool 3-bedroom, 2-bath in a great neighborhood, so I'm just going to fly by it and take it. And you get that waiver. So that waiver will help the association, the real estate professional avoid the litigation. What it won't help you with is get any referrals. Yeah, people who pay these special assessments that I mentioned earlier, yeah, they rarely call the realtor back and thank them and give them more opportunity. So if you're looking to create more referrals and give the best service possible, don't let that association get away with that. As David mentioned earlier, it's not their choice. The association is required by law to provide this information to their membership. So if you remind them of that, and specifically remind association counsel that you may have some negative financial consequences for their failure to produce the legally required documentation, you might get some movement on that. About once or twice a year, we get what we call a rush order, and that means that escrow is about to close and it's being delayed because they don't have the finances or the reserve study. So while you certainly can have a transaction that doesn't include a reserve study, my recommendation is no, make that association produce the information so that they can make an informed decision so that you can have a happy client that calls you back. All right, so in summation, the things that we've talked about today, it's very important that you as a real estate professional make an effort to ensure your clients have copies of all the HOA documents, CC&Rs, policies, etc. And I believe we have given it to you. If not, let me know and I will send it. We have included a copy of the Davis-Sterling Act for you guys here today. Most importantly, you're going to want to look at 4525 and 4530 because that's all the documentation that you have. I know a lot of you came here today like, what information am I entitled to and how do I get it? I saw one of the questions earlier about what are these small HOAs that may not be professional managed? Well, you just simply have to remind them of their obligation. And so we've given you the specific areas of the civil code that you can cite. It's very important to make sure your clients understand the restrictions on that community. As David mentioned, parking restrictions, guests, parties, etc. Particularly now with the Airbnb, we've seen a lot of changes to CC&Rs as it relates to that. So make sure your purchasers are aware of the limitations of that particular community so they don't run into problems later. And then make sure your clients understand the financial condition of the HOA. As I said, I wouldn't recommend you have a transaction without a reserve study. Without a reserve study, you're literally flying blind. You're just hoping that that association has money. So if you have a reserve study, you've got a much better financial picture of the HOA. And of course, you might have to get it for a lot of financing. And then of course, recommend your clients consult with a licensed insurance agent. We had some questions in there earlier about, well, how do I know what to get? Well, that's what your broker is going to be able to tell you. A good broker will be able to review the HOA's policy, see what limitations it has, and then it will be able to customize your HOA 6 policy so that you have all the coverages that you need, but none of the ones that you don't. So we certainly recommend that before you facilitate the transaction, that all of your clients seek and get the services of a licensed insurance agent who is familiar with HOAs. So with that, I think we actually finished early this time. I don't think that's ever happened. So I have an open for questions. I will be here for a few minutes to answer those. I think some of our other fine folks are with us. But other than that, we have completed it for today. Thank you all very much for your participation. I look forward when we can do this in person again later next year.